So if you came here through a link from one of our other media platforms, you'll remember that I said that the version of assessing our defenses that was previously given was kind of the diet version. Here we're going to go through a little bit more of a detailed analysis as to what your rights are and what we need to look to for potential defenses. And it's very simple as to why. It's extremely important that anybody charged with DWI knows that these things are not as simple as putting you behind the wheel and saying you got a few in you. The state has a series of burdens to satisfy before they can even think about hanging this on us. And we're going to hold every single one up. Now, there are going to be times that a defense or a way of looking at something is going to be a little more applicable to one person's case than another. But again, we're going to go over everything line item, make sure we're not leaving any stone unturned. So first up, I spoke earlier about reasonable suspicion. And that's just kind of the colloquial way we talk about the right for the officer to come in contact with you in the first place. It's not a terribly high burden of proof. We're not talking about guilt beyond a reasonable doubt. But it's not a layup either. It's not a situation where an officer can just say, business is kind of slow tonight. Let's start pulling people over and seeing if they're up to no good. You know, if you look at the broad spectrum of things that people are stopped for, you know, down at this end, you've got things that are effectively binary. Your lights aren't on in the middle of the night. There's no tag on your car. You know, if those things are going on, that's readily observable. I think anybody would be hard-pressed to say that an officer should have just ignored that. At this end of the spectrum, though, you've got things that people get pulled over for that are unconstitutional. And you know, while these examples might be a little bit hyperbolic, it doesn't change the fact that people get pulled over for reasons that they shouldn't. Being a black guy in a white neighborhood. Driving slowly through an area where a known prostitute lives. In that second example, maybe it draws the officer's attention to the situation, but it's not enough that they can start blue lighting people. And then everything else kind of falls in the meaty part of the curve, and that's because it does require some level of discretion from the officer. Next burden of proof that the state has to satisfy is probable cause. And probable cause is the burden of proof, not that it takes to simply pull you over, but now we're talking about the burden of proof that it takes to arrest you. Now, historically, the state has always been able to rely on a portable breath test. And this is a few years ago that they were, but that was kind of their go-to because it made life real easy. Get somebody to blow into a handheld device on the side of the road, that thing says 0.08 or higher. I don't care if you're juggling cats and doing everything indicative of sobriety, they've got the right to arrest you. That's no longer the case. Now if the state wants to show that they have the right to arrest you, they have to do so based on the subjective standard of what I'm just going to refer to as actual impairment. And that's just like an officer or even a layperson would take a look at somebody and determine whether or not they should or shouldn't be driving. You know, what's the manner of driving like? What's their demeanor like? What are their dexterities like? Do they have a record that the officer knows about before arresting? All of these things can come into play when determining whether or not probable cause exists. Next, criminal procedure. I'll keep this simple. It's all about dotting I's and crossing T's from the state's end. Oftentimes this can involve the authentication of the chemical analysis or determining whether or not somebody's processed in the proper way. And then lastly, reasonable doubt. It's just like you see on Matlock. If all of the elements are considered and all of the evidence that has been given to the court are taken into consideration, is there a reasonable doubt as to whether or not somebody was driving while impaired? All those elements have to be hit. It's not just a situation where the state has to prove impairment. We have to prove PVA. They have to prove operation of the vehicle. All of these other things that have to be taken into consideration go into whether or not we have a defense. I hope this is helpful. Certainly this is still a very diet version of a full analysis. But if you have any questions with respect to a DWI, even one that you've already disposed of but you need some clarity on, please feel free to contact us via phone, via email, and we'd be happy to help you out.